Okay, well, welcome everybody. I'm Professor Michael Epstein at Southwestern Law School, and I am honored to be here in my capacity as the director of the Amicus project at Southwestern Law School. I'm holding up the brief that we're going to be talking about today, and I'm bringing people in out of the waiting room while I speak. And just very briefly, a short introduction about the Amicus project. The Amicus project is a pro bono outreach program at Southwestern Law School that I developed and founded back in 2013 that matches a student with either a practitioner or a faculty expert so that they can team up to develop and prepare a brief. The brief does not have to be in the United States Supreme Court as this brief is. It can be in any jurisdiction. Basically, my role as the director is to look for interesting cases and interesting issues to invite students to apply to be considered for the project. If they're admitted, then I try to pair them and match them up with a faculty member to be their direct supervisor, someone with specific expertise in that area. That in this case would be Orly Ravid, the director of the Biederman Institute. The student who applied is Suna Izgi, and she will be taking the lead in discussing her brief shortly. And I say her brief because it really is a brief that Suna Izgi that she labored over, that she was responsible for. My role is to look and bring the student in to the project and match them on a case that I think would be relevant to Suna's or any student's particular interest. In this case, it was a copyright issue, which I knew Suna would be thrilled to be involved with. I also knew that this would be something that Orly Ravid would love to work on. So I kind of act like a matchmaker and I match them up. And in many cases, as with this one, if it's an issue that I have some passion for, I also will be part of the mix. But generally, my role is to guide the process smoothly to make sure that that we meet all the court rule requirements and deadlines that the courts ask of us. And it's an interesting it's an interesting program here at Southwestern. It's really the only program of its kind that I'm aware of in law schools, because when Suna is brought in to work on this brief, she's brought in for credit. She gets 2 credits, graded credit. She gets a grade in this class, and the grade is based on the academic work, the research and drafting that goes into this brief. Now, if the brief gets filed, that's terrific, but you don't have to. It may be for some reason a brief might not get filed. She'll still get her grade based on the academic work. So there's an academic component to the Amicus project, but there's also a professional component. I will tell you that in the many briefs that I've done over the last 8 years, every one of them has been filed. But I say this because it's not up to us. It's really up to a court. We often have to get permission by the court or by the other parties in interest to have our brief filed. We're not the parties. What we do in the Amicus project is we prepare friend of the court briefs, Amicus briefs that are designed to persuade or inform judges on the positions that we care about, that we think are the correct positions. But it's not a given that any of our students' briefs will be accepted by the judges on the court, especially in the Supreme Court. But I'm thrilled to tell you that we've, the students, every one of the students who have been in the Amicus project since its beginning have done first-rate professional work. We've never had an issue with a court saying, this looks like student work. It's not good enough. The courts have been, I think, very satisfied with our work, and in some cases, the courts and others in the popular press have cited to the work that our students have done in the Amicus project. It's been a really great experience for me as the director, and I will tell you that, this goes back to 2013. The first student in the Amicus project is Professor Ravid, now Professor Ravid, she got the ball rolling, and it's a thrill for me to bring her back into the Amicus project now, all these years later, as the Amicus supervisor. So I'm not going to go on much more about the substance of the brief, because I want Suna Izgi, who has become an expert on the issue of the copyrightability of characters and how the circuits treat character copyright. I'm going to turn this over to her, but at the end of her presentation, and Orly Ravid will chime in as she sees fit or when spoken to, she said, during this presentation. At the end of Suna's presentation, we'll have some opportunity for question and answer. We'll open it up for questions you might have either about the substance of the brief, and it's a terrific brief. I'm so proud of this work, Suna. You did, a real service to the court, I believe. But if you have questions also about the Amicus project in general, we can address them later in the Q&A. So I now turn it over to Suna Izgi, who is going to talk about Moodsters versus the Walt Disney Company, our Amicus project brief.
Right,
Suna,
thank you.
Let me share the screen.
Oh, let's see.
Let's see.
All right. I think
you can do it.
I can do it. Yes. Thank you for that introduction, Professor Epstein. Thank you, everyone, for attending and being interested in character copyrightability. Copyright can sometimes be dry, but when it comes to characters and entertainment related projects, there's always something interesting happening. So I hope to be able to maybe teach you a few things or at least entertain you during your lunch break. So we already addressed this a little bit, but I wanted to first go over what an amicus brief is, because to be quite frank, I wasn't entirely sure when I was approached about this opportunity, and I thought it would be just good to provide some context. So an amicus brief is a persuasive legal document filed by a non-party to a case, usually while the case is on appeal, and the non-party files a brief because they have an interest in the outcome of the case. Typically, this interest is the law that is going to be applied to a particular area, which is what our brief was about. And this brief was filed with the Supreme Court of the United States in support of the petitioner, the Moodsters Company, on its writ of certiorari. Basically, what this is that the Supreme Court takes a bunch of petitions to review cases every year, 7,000 to 8,000 even, and they only take about 80. And in order to actually grant a petition, you need to get 4 justices to sign on. There's no percentage minimum or anything like that, but usually it comes out to about 1 to 3% of petitions being granted each year, which makes it very difficult to actually argue a case at the Supreme Court. So I'm going to give you a little bit of background on what this case was all about. So as you will see on your screen right now, these are the 2 ensembles of characters that were at issue. On the left is the Moodsters. On the right is the characters from Disney's movie Inside Out, which you might have seen. It came out in 2015. So the Moodsters Company is owned by Denise Daniels, who is an accomplished child developmental psychologist. She spent about 40 years of her career working with children and helping children identify and deal with their emotions. And what part of her practice and part of her work was creating these Moodsters as a vehicle of continuing her work with children. So the Moodsters, as you can see on the left-hand side, are anthropomorphized emotions, and each mood has a color. And they have been featured in merchandise, in books, and all sorts of products. And the issue in this case was with respect to them being a television show. So she wanted to develop these characters and make a TV show that was animated, geared towards children. And she was looking for production companies and studios to partner up with her. So she was talking with, I believe, Disney, Pixar, and DreamWorks. So as a part of this project, her team developed an animated pilot. They also developed some pitch materials, which included a Bible. And a Bible is just an industry term for sort of like an informational packet of like what the characters are like, what the setting is going to be like, what the genre is, and all that stuff. So her team actually did copyright the pilot and the Bible. So they registered it with the US Copyright Office, but the characters themselves were not copyrighted, which will matter in a little bit. So from the year 2005 to
I just want
2009.
to quickly interject there. I mean, characters don't get copyright protection separate works.
Right.
They protection within the work.
Yes, correct. So yes, that is absolutely correct. So basically from 2005 to 2009, Daniels was in talks with Disney about developing the project and working together, but nothing ever came to fruition until in 2015, Disney released the movie Inside Out. So for those of you who haven't seen Inside Out, it basically features these characters that live inside of a girl who is coming of age and turning into a hormonal teenager. And the characters are her emotions. And it kind of does like this deep dive into a child's developmental psychology. So you might be thinking, wait, this sounds really, really similar, which is what Daniels thought and led to this lawsuit being filed in the Central District of California. So the claim that she brought, well, there were two claims. The first was breach of implied contract, which is a Disney claim, which we will not talk about during this presentation. And the other claim, the second claim, was copyright infringement of the characters. So the issue with being able to bring a claim for copyright infringement is that you first have to be able to allege that you own the copyright in the work. And generally, if you have a registration, this is easy because that's just prima facie evidence. But in this case, the plaintiff had to make a case in her complaint of why she owned the characters and why the characters were in fact copyrightable. And she had to do this by applying the Ninth Circuit copyrightability test of tell and the story being told test, which I will get into all of those in a little bit. But the main thing that you need to know is that the district court granted Disney's motion to dismiss, reasoning that the characters were not copyrightable, essentially. And in its analysis, it compared the characters to James Bond, Godzilla, these very well-known, widely disseminated characters, which is also another issue. So once they lost at the district court, the plaintiff appealed to the Ninth Circuit, basically arguing that the district court erred in saying that the characters were not copyrightable. There was also a procedural argument that we will not really touch on at this point. But basically, the important thing about the Ninth Circuit ruling was they affirmed the decision, holding that the characters could not be copyrighted under the Towel test. But they also brought back another test called the story being told test that actually hadn't really been in use until this case. So that was a little problematic on its own, which I will get to again when I get to the brief. But they basically discussed this idea of the idea expression dichotomy, which is a term in copyright law, which basically means that you can't copyright an idea, but you can copyright expressions of those ideas. And the issue with characters is that the line between an idea and an expression is hard to distinguish between. That's why these tests have developed so that we can ascertain whether a character is an original expression. So basically, with the Ninth Circuit's ruling was problematic for the plaintiff because they set a very high bar for character copyrightability, and it kind of just added to the confusing body of law that already exists, which led to the appeal to the Supreme Court. So this was the timeline and the briefs that were filed. The plaintiff filed their petition on August 3rd. We filed our brief on September 4th, which meant that I think I was admitted to the program like 2 or 3 days before they filed their petition, and the clock began to run. And it was basically 3 weeks of intensive research, lots of writing and rewriting, lots of late night Zoom calls with Professor Ravid, who I appreciate for helping me with everything and being a great advisor. And it ended up being filed successfully, no formatting issues, no legitimacy issues. And another amicus brief was filed in support of the petitioner by the California Society of Entertainment Lawyers. Our briefs essentially argued the same things, but we made our arguments more as a matter of law as opposed to applying the tests to the facts, whereas the California Society of Entertainment Lawyers' brief was much more fact-based and talking about why this case itself, the outcome was unfair. The interesting thing about the timeline of events was that initially Disney had waived their right to respond. They were just going to let the court take the petition and kind of, move on with their lives. But after our briefs were filed, the court actually requested them to file a response to see what they had to say. While ultimately the petition was denied, I think that it's still a question that should be adjudicated in the future. And we did have a new Supreme Court justice come in at the end of last year. So who knows, maybe it would have been taken if Ruth Bader Ginsburg were still alive. But the main arguments that the petitioner had in their brief for their writ of certiorari was that the court should take this case to define a uniform standard of test of whatever the test would be to apply to characters and whether a character can be copyrighted. Because as you will see in our brief, there are a lot of approaches taken across the country, and some of them are more lenient than others, and it leads to inconsistent results. So that was one of their arguments, which we supported. Their second argument was more procedural, and it had to do with the fact that the copyrightability issue had been adjudicated on a motion to dismiss. So the main argument for the Supreme Court to take the case was for them to determine whether it's a question of law or fact and whether copyrightability can be discussed and decided on a motion to dismiss without further evidence. So we didn't touch that part. We just looked at the bare law and how characters can be copyrighted. So our goal with the brief, as we stated before, was to make an argument as a matter of law by discussing the tests that exist and advocating for a new standard, which was a Supreme Court case called Feis, which I will get to, and kind of highlight the intrinsic unfairness of how characters are handled in the courts and how this really goes against the purpose of the Copyright Act and how we're really fighting against independent creators by upholding these kinds of decisions. This was our question presented. So can characters be denied copyright protection under the US Circuit Courts of Appeals tests that require more than a modicum of creativity in order for a character to be copyrightable, in violation of the plain language of the Copyright Act of 1976 and this court's decision in Feist? That was a mouthful of a question, but that was what we wrote about. So we had three main arguments, which I touched on earlier. So the first argument was to set up what standard we wanted to apply, which was Feist, and why it could apply to characters. So basically applying the analysis from Feist and that standard to characters and explaining why these tests require more than Feist does. The second section of the argument was about detailing all the different tests that are being used and then applying Feist to those tests and saying why they don't work. And then the last argument was more as a matter of policy, kind of highlighting the inconsistent decisions that have been made and how these really disenfranchise independent creators and deprive them of their constitutionally granted monopoly over their works, which is one of the purposes of the Copyright Act, and their right in gross, which again, I will get to. So in the first argument, we wanted to set it up. We wanted to tee it up to be like, okay, this is a logical standard. It's simple, it's easy. We actually don't need to overthink it that much. So if you've taken copyright or entertainment law or about to take copyright, a work is copyrightable if it is a fixed original expression. And the Supreme Court set the standard for what originality is in Feist Publications versus Rural Telephone Services Company. And the Supreme Court basically said that a work is original if it's a product of independent creation and it contains a modicum of creativity. So independent creation just means that the work owes its origin to an author. It wasn't copied from anything, like a human made it. Modicum of creativity means that basically it's a very low threshold of creativity. It doesn't need to be unique. There are no quality evaluations that go into it. And basically they said only works in which a creative spark is utterly lacking or so trivial as to be non-existent don't pass the test. So we made the case that, well, Feist says that we don't have to prove a lot of creativity when it comes to characters, when it comes to showing originality. So why do we have all of these tests that only apply to characters and no other works that require far more than what Feist does? And there's no justification based in statute, case law, or policy to support this different way that we're treating characters as a matter of law. So then in order to back that up, in our second argument, we got to the tests that are actually used by the circuit courts and how they violate Feist by requiring more than a mere modicum of creativity. Professor Ravid, did you want to say something?
Well, I mean, not necessarily, but I will say, as far as the story being told test, that's a test that only the Ninth Circuit applied. It created it in the late 70s.
Yep.
It seemed to have abandoned it. It was only applicable to literary characters. It seemed to have abandoned it. It was criticized by the Second Circuit and other circuits. And then the fact that it revitalized that test in a very unclear manner in this case at the court level is very concerning. And even Disney, in its own briefing, acknowledged the fact that the courts do have a sort of higher standard for creativity, for originality, for characters.
Exactly. So that's why we started off with the Ninth Circuit from a persuasive standpoint, because that's where this case came from. And that's where the most, in our opinion, the most flagrant violations were occurring. So the Ninth Circuit has two tests that apply to character copyrightability. The first one is the story being told test, and the second is the Towle test, or the Towle test. Or we can refer to it as the Batmobile case, which we'll get to. So according to the story being told test, a character is only copyrightable if it constitutes the story being told. And this standard was articulated in 1954 in the famous Sam Spade case. And it just sets a very high bar because you're requiring a character to be the essence of the story, which is, I mean, that requires far more than just a modicum of creativity. However, in 1978, the application of this test was only limited to literary characters in a case called Air Pirates, which also involved Disney, I believe, because the Mickey Mouse franchise. And they said that the test is only limited to literary characters because graphic characters are easier to visualize, they're more distinctive, they're more descriptive, they're easier to see in your mind's eye. So after Air Pirates the Air Pirates decision came down in the Ninth Circuit, the story being told test kind of just didn't really come to the forefront anymore until this case, which interestingly enough were about graphic characters, not literary characters, because they were physically represented, which was another issue. And essentially, I just said this, but we argued that the story being told test violates Feist because it requires far more than just the minimal degree of creativity and originality that Feist, so the Supreme Court, requires.
And actually, one more thing to chime in, I think I misstated the dates, but when the story being told test first came into being in, like you said, the 50s in the Sam Spade case, it actually is considered to be dictum because that case that involved the Maltese Falcon was resolved on contract issues. And there was no even need to have ultimately the copyright had to be licensed, but could not be owned by Warner Brothers. So that's what's particularly troubling about this test, that A, was not necessarily even meant to be precedential and is considered dictum and bad law. And then it was limited by the Ninth Circuit in 78 to be just applicable to literary characters, and then gets sort of carelessly revitalized in speaking about graphic characters, which are usually given a better treatment, more easily protected in the circuits.
Right.
And that's one thing that is consistent across the circuits, is that graphic characters usually are better protected.
Right, right. So basically, the Ninth Circuit is a mess. And so then we moved on to the second test, which is called the towel test. And basically, this was a case where the Ninth Circuit held that the Batmobile was a copyrightable character. And they went through all the different character copyrightability case precedents at that point, and they basically just articulated this new standard. So according to this test, a character is copyrightable if it has physical and conceptual qualities, it is sufficiently delineated such that it has consistently identifiable character traits and attributes, and third, it's especially distinctive such that it contains some unique elements of expression in order to be copyrightable. So just even based on the elements of the test, you can already tell just based on the words that it requires more than a mere modicum, because physical and conceptual qualities favors graphic characters. Suggesting that a character has to have persisted over time, it means that it's going to be benefiting owners who have more resources, like studios who can afford to have their characters persist over time in multiple works. So it's basically rewarding commercial success over originality and expression, which is what the Copyright Act is meant to promote. And essentially, when you're also going into the distinctiveness prong, it borrows from trademark concepts, which is inaccurate. It borrows from evaluation of the quality of the character, which is not a subjective evaluation that a judge should be making when evaluating a copyright or whether a work is copyrightable. And this is also enumerated in Supreme Court precedent. So basically, we said that the Ninth Circuit uses these two tests that impose far too high of a standard, and they violate Feis, and we already have precedent that governs this area, so we should just be applying Feis to characters. Then we moved on to the Second Circuit, which uses the sufficient delineation test. And under this test, a character is copyrightable if it is sufficiently delineated. So the problem with this test is that there's no clear standards governing when a character becomes sufficiently delineated. Like generally, we know that, if a character has common and general characteristics, it's probably not sufficiently delineated and more of a stock character. But again, we don't really have a lot of guidelines, so you have judges making subjective evaluations, which is what we don't want when it comes to copyright as a matter of law. And this essentially comes to the same argument with Feist and how this test violates Feist. It's because it requires something more than just originality and a modicum of creativity. Without having objective guidelines, courts can kind of do what they want and just subjectively judge a work for themselves. Then we moved on to the Seventh Circuit, which uses the distinctiveness test. And this test seems more lenient because all it requires from a character is to just be more than a stock character or a scène à faire. And again, but the standard just isn't very helpful in evaluating a character from a judicial standpoint. And we argued that this still violates Feist because even though it seems more lenient, distinctiveness is a trademark concept that has no place in copyright law. And trademark is a right that is appurtenant to use, which means that you are entitled to protection through the use of your trademark, whereas copyright is a right in gross, which means that as soon as your work comes into being, you own the copyright, regardless of whether you've registered it. So we were basically saying that consumer perspective or the perspective of a judge should not matter in evaluating whether a character deserves protection. And that is why it violates Feist. It still requires more than a modicum of creativity. So after going through the standard we wanted to advocate for, which was Feist and modicum of creativity, minimal threshold, and going through all of the tests that are followed by the circuit courts, and just to note, the other courts just kind of follow the Ninth, Second, and Seventh Circuits. We then got into our last argument, which was largely our policy argument. Talking about the inconsistencies across the courts, not having reliable outcomes, not having defined standards, and how this leads to judges making subjective evaluations because of the lack of clear standards, and how even though it is difficult to determine when a character should be copyrighted, and an exact line can't really ever be drawn, as Judge Hand said in the Nichols case in the Second Circuit when they defined the sufficient delineation test, there should still be some type of standard to follow. And Feist is a pretty clear one at that, because it defines originality as just a low threshold. So instead of analyzing whether a work is copyrightable, maybe we should be shifting our analysis to whether it has been infringed, because the Copyright Act and the purpose of copyright law is to motivate creative expression by giving creators a limited monopoly over their work for a limited amount of time. This gives an incentive for people to create things because they know that only they can use it and they can license it out or whatever. So with the tests that are currently being used, especially in the Ninth Circuit, the outcomes tend to reward those with the most money and marketing resources, because a lot of these opinions draw comparisons to characters like Godzilla, Superman, James Bond, like these very popular, widely disseminated characters that have persisted over multiple kinds of works, which yes, they technically meet the standard, but it's really unfair, because think of all the millions of dollars that go into that. And then you're just left over with your independent creators who are just trying to who will likely not win. And the Ninth Circuit is notorious for favoring Hollywood when it comes to that. So that was basically the argument. Here's our conclusion, if you would like to read it. And that was our brief. And as an outcome, I said this, the petition was not granted, but the brief is still officially on file. It's searchable. I can add it as a publication to my resume. And it was a very rewarding experience. I learned a lot. I definitely became one with character copyright law in 3 weeks. And thank you so much for the opportunity, Professor Epstein and Professor Ravid. And I will stop here. Who do you think should have won?
I think you should turn the brief into wallpaper in your home.
Yeah,
Sorry.
I mean, honestly, there was a lot of blood, sweat, and tears that went into it. So,
well, I mean, did you ever imagine, Suna, that you would become such an expert in the copyrightability of characters in such a short period of time?
Never. I mean, I knew a little bit from copyright law from the class, but I think we cited to about 40 cases, but I read about 200. And obviously the treatises and stuff like that. So it'll be very difficult to forget what I've learned.
That's correct. Lots of give and take. And that's one of the things I
Yes.
love as director of the project, because it was a learning experience for me as well. I don't teach the copyright class. I have some knowledge of copyright and certainly some knowledge of Feist, but it was really, really getting in deep into the various tests and these various issues. I would remark that you were tapped to do this in August, and your brief was filed when?
In September.
Yeah.
So it was like a month, I think, in total.
We had about 5 weeks total, which brings us pretty close to the minimum that amount of time that you would have to spend on it in order to get academic credit. We require a little over 4 weeks generally. Keep in mind that the practicum, which is the class that Suna was admitted into, she enrolled into to work on this brief, it's a class that is on rolling admissions. It can happen at any time. It's the only class at Southwestern where it's not tied to our academic calendar. This is because it has to be tied to the court's calendar. We don't decide when the brief is going to be due. The court decides. And we've had it's not only the Supreme Court, it can be a state court. We've done California Supreme Court, we've done Ninth Circuit, we've done First Circuit, we've done a number of different jurisdictions. They decide when the brief is going to be due. And in your case, we had about 5 weeks, but they were 5 really, I loved it. I thought it was really very intellectually stimulating. I know you had a lot of passion for it, Suna, but you look back at it and you look back at it fondly.
I do, but I also think that I would also recognize that there was a lot of pressure, and I learned just what my limits are, and that's always good to know in general. But it was very rewarding, and I definitely feel like my writing skills exponentially improved in I guess 3 weeks of active rewrites and edits.
Yeah, in that sense, it operates, the practicum which is the 2-credit graded course. It operates like an independent study in that sense, with your immediate supervisor, who is Professor Ravid, chiming in and going through drafts with you, with me as the director of the project doing the same, and also making sure that you're rules compliant, so that we have a smooth landing when it does get filed in the court. And it's a measure of the quality of your work, that amicus briefs, are signed on by people who aren't necessarily, that they can be signed on by others who very much believe strongly in the arguments made, but maybe they didn't write the brief. That's, we ask sometimes people, are they interested in signing on? And it's a measure of the quality of your brief that the one person who did sign on to your brief is Professor Robert Lind. I will say that Robert isn't here today. I know he's very proud, and he's told me how proud he is of what you did, Suna, in this brief. But those of you who know Professor Lind, he will not sign on to a brief. He won't sign on to anything unless he is committed to it and he really believes it. That's, kudos to you, Suna, because that was one of many indicators to me that this was going to be a home run. And it was a home run. I mean, I think you've made a really good point. We knew going into this that the odds were against the case being taken, greatly against. You gave some of the statistics. But we also know that we contributed very much to the debate at the court. You've already pointed out that Disney wasn't even going to file a brief until the court said, we want you to file a brief. And that happened after we filed. And for me, the most important aspect of our filing is that we made arguments that were not at all made by the petitioner. The petitioner really didn't focus on what we were focusing on at all. And that's the whole point. We don't try to do vanity briefs, where we're just going to file in the name of some organization. We do file sometimes on behalf of other pro bono organizations, but there's always a strategic significance of our brief. We try to make briefs in the Amicus project that aren't being considered by the party that we support. And that's precisely what Suna did with Professor Ravid's supervision in this particular brief. So I'm thrilled. There are some experiences that are of longer duration, where you have more time in a court's calendar than you did, but I was certain that you'd be able to carry the oars, so to speak, and get through this in the 5-week time frame. And I'm just delighted that you did. So at this point, if Orly, if you have anything you want to add, I know that you've been chiming in as needed, but please feel free. And then after that, we can turn it over to some questions and answers. And the rest of you, you can put Suna to the test and see how well she's learned these issues.
Yeah,
So,
I chimed in a bit, and you did such a great job. I really don't have much more to say. The only one thing I think is just interesting, we did not make this the subject of our brief. It was obviously the plaintiff appellant petitioner's point, which was that there is also a split of authority, and Disney acknowledged this with respect to whether or not the copyrightability is a question of law or fact, or a mixed question, such that it could be dismissed at the stage that it was, right, on a motion to dismiss, 12B6 motion. And the Moodsters company, they had expert witnesses and all that kind of thing, and obviously they never got a chance to be heard by the trier beyond the motion. So just to know that that's also an issue. We did not touch it, but that was an issue in the case.
Yeah, so I think it's really important to stress, and I think Orly and Suna, you will remember this as well, that our brief was a brief on the law, and it's very easy to start getting trapped into arguing the facts, which is, and that's what, that's what Moodsters Council was really trying to do. They were looking at the facts. For us, it almost didn't matter what the facts were, because we were really arguing that this is a departure from Feist. And it almost, I mean, the Ninth Circuit was an example of this problem about basically moving away from Feist, but it was only the one example, because even the other tests were problematic, maybe less problematic, but under Suna's reasoning, they were just as problematic because they moved away from the modicum test that was in Feist. And I think, I'd like to think that that would have been very interesting. That would have led to some interesting discussions for this, among the clerks and among the justices. Because I think that's a big deal, because remember, Feist is the Supreme Court's test. And we're discussing circuit tests that basically seem to be a departure from Feist. So I'd like to think that maybe this just wasn't the year for this case to be taken. Maybe they had other.
Or maybe the facts were, I think that's where the facts might matter, in that it just wasn't the right case. And the odds are always statistically against the court taking it up. And also we did lose a justice who was so focused on copyright and so favorable to plaintiffs in the cases. So
I think initially that's true. And I think that's why Disney, of course, maybe decided, can't speak for Disney, but maybe that's why they decided that they weren't even going to respond initially. But at least I'd like to think that Suna's contribution here is that, you elevated the arguments in this case, so that they took it seriously enough to say, Disney, what say you? They didn't actually take it ultimately, and who knows why. It's not necessarily, we all know that a decision not to take the case is not necessarily should not be interpreted negatively on the arguments. It's very possible that these issues will come again to the Supreme Court in the next few years. And I'll just say that if that happens, Suna, I hope that you'll be, an alum who will be an Amicus project supervisor to a future student who will be working in the practicum on those issues in that case. It would be great to see that happen. So let's open it up for Q&A. Just say who you are, and if you do want to ask a question, it'd be great if we could see you, but if possible. Brittany, hi.
Hi. First of all, so proud of you, Suna. We've been friends since orientation. I'm so proud of you. I would like to know, what was the most difficult part for you? Was it more the research or more the writing aspect? I know you did it in such a short amount of time. So what do you think was the most challenging thing for you?
That's a great question, and thank you. I think the most challenging part, honestly, was being able to take a stance in my argument, because I found so many cases going for both sides, and it was difficult to prioritize sometimes and kind of reorient to my point of view, because we were supporting the petitioner. So I think that it took the most time to formulate the arguments. But once the arguments were formulated, it became a lot easier to write. And it was just a lot of information to synthesize. So that definitely made it challenging.
Other questions for Suna? Or for Professor Ravid as well?
I'll just say that it was a fun experience when I did it as a student, and it was a fun experience supervising. So I really recommend it for any of you students.
And I will tell you that Orly, already a scale student, so she was busy enough at the time. If I recall correctly, Orly, you worked on 2 briefs. You just decided to come back for a second brief after basically, killing it on a Ninth Circuit brief. You decided, I want to have some Supreme Court experience.
Wanted to have the wallpaper Suna has, so that's what I did.
Well, you have Wallpaper, but you also you have search engine results on Westlaw and in the other databases, and that's the gift that keeps on giving. So
thanks to you creating it's a really cool experience to be able to do that kind of high level thinking, research and thinking. It's a really great experience.
Yeah.
Yeah, it's Moot Court, except it's not moot. Roy.
Hi, congratulations, Suna, on your great work. And I was wondering, when you have so many cases to work through, how do you create a strategy to read the cases, come up with rules, and decide where to devote your time?
Well, thank you. And that is a great question because it was a very big undertaking. So I'm a huge fan of spreadsheets. I started using spreadsheets for cases even back in 1L in legal analysis and writing in our writing class. So basically what I did was I just had a monster spreadsheet and I would just add the case names and a quick synopsis of what the case was so I could remember what test it went to, like what circuit it was from, and whether there were any arguments in it that I wanted to cite to or any examples that I wanted to cite to, and just kind of notes. It ended up being pretty long, but once I was able to at least categorize them by circuit, I could just only look at those while I was writing that section. So that made it a lot easier, but it was, it did feel overwhelming at one point.
Good question. Other questions for Suna or Professor Ravid, or questions about the Amicus project? All right, everybody's shy today.
They might be zoomed out. It's probably people's 1500th Zoom in the last year.
That
the Zoom fatigue
true.
is real.
It's really real. It's like
yeah.
and I want to just zoom out.
It's true. This was also the first time we did the Amicus project fully on Zoom, which was kind of interesting. But we managed it well, I think, and Suna, I should say, you really managed it well. I mean, it's you talk about it being overwhelming, but that often is the way it is in appellate litigation, especially if you have a brief in there. And it's a measure of your success that you managed it so well. There wasn't any, she was not pulling her hair out, but I think I think you decided that you were going to be really organized and really structured in your work to make sure you get things done on time. And the way, again, the way it works as in the practicum is that your assignments are basically negotiated at the beginning, at the time you enroll, as to the various milestones that you have to hit. Finishing, working on your outline, finishing your outline, getting it approved by your supervisor and by me, getting getting your research completed, getting your rough draft, your first draft in, moving through a series of drafts, the citations and sourcing. Everything has to be done in accordance with a research plan that Suna developed with Orly's contribution and my help over that 5-week period. So it's not as if we just say, hey, Suna, welcome to the practicum. Here, get to work. It's not like that. It's structured. And, Orly was there every bit of the way, even though I know Orly was also super busy at that time. But in that sense, it really is, it structures what being an appellate litigator is really like. You were acting, and you were functioning really as a lawyer would, with a real deadline. And ultimately, the court's deadline, we have to send this to a printer. There are 4 Supreme Court printers that the Supreme Court requires brief filers to use. And that deadline is etched in stone. So there's, you know, in the Amicus project, there's no way you could ever say, gosh, can I get an extension? So we build that all in, and you know, ultimately, Suna, you had no problems meeting the various deadlines that you would agree to, and I find that you know, the hardest part about the Amicus project is getting into it if you're a student. Once you're in, the students have all done just beautifully. You know, they get the work done and they do it at a very high level. It really is, it's remarkable. And I'm glad that you had this opportunity, Suna. You really shined.
Oh, thank you. It was a really great experience. And I think it just makes Southwestern that much better because there is this opportunity for students to do something like this before they even pass the bar. So it was very rewarding, and thank you for accepting me.
Well, thank you. You earned it. Tiffany, you have a question.
Yes, thank you. And thank you, Suna. Thank you, Professor Ravid and Epstein, for this awesome presentation. Suna, I'm just interested in how you managed, I know it was during the summer, it sounds like, but how did you manage doing this and maybe an externship and your other courses? I really like this topic because I worked on some similar topic in my last externship. So thank you very much for doing this.
Oh, great. Yeah, that's a good question. So at the time, I think the brief was filed in the first week of classes, if I remember correctly, something like
Pretty
that.
much,
So, yeah, so the bulk of it was before school started, but I did have a clerkship in entertainment litigation. I think it just came down to time management at that point. There were some days when I went to bed really late, or there were some days where I just woke up really early and got everything that I had to do done. The most time consuming part of it was the research and like formulating everything. But once that was done, and once at least I had a first draft and I knew I had something to work with, that part was not as time consuming because at least I knew where I was going. So I would say the first 2 weeks were the craziest, but it got easier. And then as it kind of got closer to its final form, it was not as time consuming. Formatting the table of authorities, though, that took like 2 hours.
It is much harder than you
the margins
think it
kept
should
moving
be.
and
Correct. We had the same problem with you, Orly, with I can remember trying to deal with it. But again, you know, I talked to other people who prepare briefs for the Supreme Court, and they have the same issue. You know, one day Microsoft will solve it, but right now it's you know, it's just the lay of the land. It's just the way it works.
It is.
Or you can have a student design software just for legal writing, and
Honestly,
that'd be perfect.
that would be wonderful.
That would be fun. Other questions? A great question, Tiffany. Other questions for Suna or Orly or for me? So I'm going to give one last opportunity for someone to have a question. And although many of you know how to reach Suna or Professor Ravid or me separately, and you're welcome to reach out and email us. I will say, seeing that there's no additional questions, I would like to close just to say that this is the first of this new series, the Amicus Project Spotlight series. It only took me like 7 years to figure out that maybe the student who is leading in the preparation of this brief should present to the community her work. And I'm glad and delighted that Suna, that you did such great preparation for this event. We will have another event coming up. The second in the series this year will be a brief that was prepared by Samantha Dennis, who is also a 3L at Southwestern, in a case in which we write about the right of education, federal right of education. The case is now known as AC, as in a minor that we're using for initials, AC versus McKee, the governor of Rhode Island. It'll be, there'll be more information about this event and the specifics of that brief coming into, I hope, your inboxes in the next couple of weeks. That's scheduled for April 8th at the lunch hour. In closing, again, thank you, Orly Ravid, for all your support. I also thank Robert Lynn for his support and for this project. But I reserve my greatest thanks and true pride in the work that Suna, you did on this brief. You made Southwestern proud.
Oh, thank you. I appreciate that.
Okay. Thank you all.
Thank you.
If you have questions, please reach out to one of us. I'm mepstein@swlaw.edu if you have questions about the Amicus project, and you know how to reach Suna and Orly Ravid. Thank you, guys. Take care.
Thank you, everybody.
And thanks for the digital applause.